Good afternoon and welcome to the Special Committee, Police and Community Committee meeting. Today is December 17th at 3 o'clock. I'm going to call the meeting to order and ask that we introduce ourselves. I'm Councilwoman Ortiz, I'm the chair and represent District 3.
I'm Councilwoman Hiller and I represent District 1.
We also have with us,
City Manager Brent Trout.
Chief of Police Brian Wheelis.
thank you. Mike Padilla was with us and then he wasn't with us, so he is at home ill today. So we wish him a speedy recovery. Okay, let's go ahead and start with approval of the minutes.
Move to approve.
Okay, it's been moved and I'll second it. All those in favor, say
Aye.
aye. Aye, it's 2-0. Then we'll go ahead on with number 3, the presentation continuation. And I'll turn it over to our police chief.
Okay, as soon as I see it should be the one that's labeled Termination Process.
We're starting on slide 10.
That's the C-post one there.
Oh,
Mine is on the Corrective Action, Progressive Discipline.
oh, Brenton, I hope I can do it now. I have juvenile procedures and progressive corrective action.
Yeah, Progressive Corrective Action.
Do you know where in this? Oh, that's the post. I wonder why that's titled that. Hang on. You may have to pull up the PDF that I.
Mine seems to be conveniently open to the right.
Yeah, it's on Termination. I've got the slide to start with, but
Yeah.
While we sort this out, Chief, would you be okay if we
Sure.
went out of order?
well, we'll have to ask I think the chairwoman would like to probably finish.
Yeah, we'll take a few minutes. Go ahead and take a few minutes.
Is this the one, Chief?
Yes, and you keep keep going. It should say Termination Process there.
Right there.
Perfect.
Very good.
Sorry about that.
Are you ready for me to begin?
Yes, please.
Okay. There we go. There we go. We left off the general presentation that we were talking about was progressive corrective action, police discipline processes, and other things related to the internal workings of employee support progression as we move through the policy compliance pieces that we have at the agency. The termination process was kind of where we were up to, termination of employment, and working through the process of how that works in the city of Topeka currently, and more specifically in the police department. But the way it starts was at the conclusion of an investigation, or once just cause has been established in the chief of police's mind, he formalizes a request via a memorandum to the human resources director here at the city, currently Jackie Russell, along with the professional standards unit summary, investigative summary that basically details out the investigation, the allegations and the conclusions that have been reached in the investigation as supporting documentation for the consideration of employment termination request memo that goes over to the HR director. Very often the case after the HR director reviews that documentation, we will set a meeting and include in city legal director to discuss the options and the recommended course of action. Once we get all of that to a consensus, then that moves forward to the city managerial review process, who ultimately makes the decision on whether or not the employment termination request is granted or not. Termination of non-probationary permanent employees requires a just cause finding. That's a due process step that's allowed. And the reason why that's in there and worded that way is members of the police department have an 18-month probationary period when they begin their employment with the city. During that period of time, if cause is established at a much lower level for ending of employment, because that allows for the performance issues to be identified in the police academy process and very early on in the field training officer process when they're initially out in the street. So it's a little different once they've been on past that probationary period as far as the steps. any appeal steps for, again, the non-probationary permanent employees, the rest of the union members, et cetera, at the police department, they do have available appeal steps through both the grievance and the arbitration processes, similar to all city employees. So that's essentially the actual down in the weeds steps as far as how we move through when we get to that level of which is obviously the top end of the progressive corrective action chart. And there was a great deal of presentation, so I just wanted to touch on it again from Kansas Seapost, and I go back to the other one that you were on. You're fine. There we go. So you have a lot of information and a presentation from the experts on the state of Kansas as far as certification requirements for law enforcement here in the state of Kansas, but also a piece that we wanted to touch on that I think gets a lot of questions when I'm out in the public, and I know that I've answered it for a number of council people as well. We complete here at the police department, and I know Seapost touched on it, but it's an important enough point for us to reiterate, I think, to the committee and to the community. If someone resigns in the course of the investigation, we still complete our investigation. And why that's so important is because we are required at the police department to do a change of status form and give that to Kansas Seapost. And that change of status form covers promotions, demotions, retirements, employment terminations, and resignations. So whenever you leave employment from the police department, whatever the circumstances are, or even when you get promoted or demoted, those change of status forms go to Seapost, and in those forms is categories that can trigger requests for them to make professional standard unit investigative file requests. They talked a great deal when they were here about Training Act violations. That's one of the categories that is marked if you resign during the course of investigation. It's marked that you resigned while there was a pending investigation, and that TPD PSU case number is cited in that form along with a brief explanation as to what the overview of the investigation was. That very often, I mean, almost to an absolute certainty, when the Training Act box is checked, Seapost makes a request to our PSU group for that. And I think they reiterated that when they were here. So that's what's important about that. What's important about Kansas Seapost is they're the ones that issue and pull the certification process that's required for all law enforcement here in the state of Kansas. So you can't work in the state of Kansas as a certified law enforcement officer without your Seapost certification. So that's why, and I think they did a great job of explaining it. That's why the back and forth communication between local law enforcement agencies and Seapost certification agencies is so important.
If I may.
Go ahead.
So with what you're talking about, what they did and what you're saying right here, I mean, one of the concerns or demands, depends on who was talking, when this whole police and community committee was started, was the issue of whether the records were accessible if someone had either been absolutely found of wrongdoing in some way or investigated. And so with what you're saying is that it might not be here, but the Seapost process provides that?
Yeah, and I think what we clarified through this process is that there's several different steps to that. One, if you resign under investigation or your employment is terminated as a result of investigation, which is a Training Act violation that has to do with integrity and those type of issues, Seapost gets a notification that's required for the change of status from local agencies that then notifies them that this has occurred and that the PSU file is available. They then ask for that report and then get it. But I think what they explained to you, and what was interesting to me too, was they have the ability to complete their own investigations too, and they initiate their own investigations from anonymous complaints that they get, and they make requests from local law enforcement agencies for records before and around these change of status forms that they do as an additional thing. But it was very interesting to me that they have put us in a position with the new director and a lot of the advancement that they've made to have us on the radar nationally as a state where wandering officers who get in trouble in different places have a tendency to avoid because of the amount of communication and records and compliance when you leave employment that goes on here. So I think that's why they were so interested in touring around the state and providing that information, and certainly accepted the invitation to come here and do that. So hopefully that a lot of those kind of urban myths and legends, or maybe they were how they were at one point, but they are not now. If you leave employment here at the City of Topeka, we don't just stop the investigation. We complete the investigation with all the findings, we make the appropriate notifications to the certification agency, and then we honor all the requests for the entirety of the records associated with that incident when they make them.
Thank you.
So you talked about bringing legal in. What legal are you talking about? Because I know the police department has their own legal counsel. So is it the city legal? Is it their own legal?
It's a great question, and I should have been more clarifying in my statement. The legal advisor for the police department works within the same chain of both the police department and city legal. In other words, he reports to the chief of police, but he also reports to the head of legal. Specifically, what I was talking about in this process, where we rise to the level of employment termination consideration, it's the head of legal that I'm referring to at that point.
Okay.
I have already talked to the legal advisor within the police department, reviews the memorandum that I complete on the first step when I send it to the HR director, making the initial request to give me guidance on the form and format of that. But the ultimate decision with the HR director, myself, and the head of legal to move it on to the final decision to be made by the city manager is actually the head of legal. So the answer is both of them at different steps in the process.
Okay. All right. Karen, do you have any more questions?
No, I don't. Thank you.
The next slide talks a little bit about some of the FOP employee contract rights that are specific to the progressive corrective action process that are all basically founded in due process rights. But the employee has the right during the notice of investigation to include the nature of the investigation and the inquiry. So specifically, they have an idea of what they're being called into PSU to talk about, so they can adequately prepare if they need to, and definitely have the answers to the questions. FOP representation as the union collective bargaining agreement union is allowed to have representation with them when they are meeting on corrective action issues with their supervisors, a commander, or the professional standard units, depending on what the particular case may be. But they have the contract right to have the FOP representative with them during that process. Time frame of the questioning has to be reasonable, related to the employee's shift. It's preferable to always do it during the work hours. The reason why that's in there is to make the notation. I mean, we are a 24/7, 365 operation. So if it's a third shift employee that we're making the inquiry on, we generally handle those inquiries on third shift to keep their body clocks and all of those kind of physiological things in line. Interviews have to be reasonable duration with breaks and allow for physical necessities. Pretty standard due process caveat there. Recording of the interview conducted by the supervisor, the commander, or the PSU unit is allowed by both management and the employee. Transcripts of the interviews can be provided to either the management or the employee if needed and upon request. The employee is allowed access to police reports and recordings that are related to the incident and or investigation. They have the ability to review those prior to the interview process. Refusal to answer questions in an official investigation may constitute insubordination and can result in employee termination. The reason why this is important is because insubordination is one of the potential one-time, it's not necessarily part of the progressive discipline scale. It can be a singular incident, a singular occurrence that can lead to termination consideration without prior incidences of it. And providing inaccurate or false information in any official investigation can lead to employment termination as well. The other piece of that is a Training Act violation. So not only can it lead to, if you don't provide accurate or you provide knowingly false information in an official investigation, it can not only cost you your job at the police department, but it could potentially cost you your certification as a law enforcement officer in the state of Kansas as well. And the last slide that has to do with this is kind of the counterbalance to the slide that was just prior, where we talked about what the employee rights were. This is the management rights, and it comes straight out of Article 21, the FOP contract. Management reserves the following rights: to direct the work of employees, hire, promote, demote, transfer, assign, retain, and recall employees, discipline, suspend, demote, and/or discharge employees for just cause, and determine the methodology, schedules, means, and personnel by which operations are to be carried on. And I thought that was important to not only have in this presentation, but also to emphasize, because there is a great deal of misunderstanding, or at least an opportunity for us to clarify what all of the rights are. Sometimes there's a focus on what the employee's rights are solely, and not necessarily the management rights. So I wanted that to be the last slide, and I wanted you to have the actual language that's in the contract, because as you can see, it's fairly strong language, and it covers a lot of the things that I think people take for granted that management has the right to do, obviously through the processes and with just cause due process. And with that, Madam Chairwoman, I'll stand ready for questions on this particular presentation.
Well, I tell you what I would like, and I've asked for this before, not from you, but even before we got to this committee, would help me. If you can, you might already have one, and if you don't, if you can draw up a chart where you would be the head of the police department, and then is it your commands or your lieutenants,
Deputy Chief,
deputy chiefs?
an org chart, an
Yep,
organizational chart?
Yep,
We have one of those.
yeah.
More than what we have in the budget book?
I don't know, but I if you could present us with one, so I could see, because, sometimes I'm always wondering where the command staffs fit in, who's over them, who's over who's over the command staffs,
Sure.
So if you could provide that, that would be great for me, to the committee as well.
Okay.
Because like when you're saying here, management reserves a right, who are we talking about? Are you talking about you? Are you talking about your deputy mayors? Are you talking
All.
about who's?
It's
who's
all
assigned?
encompassing.
Okay,
For management, executive management, staff in general. And in the beginning of this presentation, although that was a month ago, we kind of delineated out the different levels. Like a sergeant can otherwise do 3 days of suspension, but a lieutenant can do more, and all of those. But when I'm talking about management rights, these are rights that are associated with the entire management team.
okay,
But the org chart, absolutely.
okay. Karen, do you have any more questions on this?
I just want to say I appreciate that you put this in at the end, because I think you're right. There is so much discussion about the unions and their power and so on. These are pretty directly management rights that any workplace should have. Just so we've asked the question, do you find that there's push-pull with many individuals within the department or the FOP regarding all of these rights that management has to assign, supervise, and so on?
Well, I think there's always discussions that are had and collaborations that occur, but I don't think that there's any big misunderstanding between the union about the management rights that I listed there. I mean, we don't generally have issues with, say, a transfer or an assignment, which are two of those categories.
I didn't think so, but nonetheless, I wanted to ask. So.
Well, as we know, from personnel matters are very case specific. So I would say there's always discussions about things, but I think they have a pretty clear view of some of these categories that we have listed there.
Well, sometimes that doesn't occur as well as it should, because management has either come up through those ranks or is nervous about it, if you will.
I'm not nervous about it. I mean, we have lots of discussions, and I think that there's a lot of good productivity that comes out of continuing discussions about management rights versus employee rights and where those lines are and how we draw. And we learn things from new individual specific personnel scenarios we get in all the time. But overall, you asked for my general impression. I don't think that's generally a big point of contention between the union and management as to those rights.
Thank you.
Would you like me at this point to move back to the follow-up questions that were from last, because they were
Yes.
related to this
Sure,
presentation?
absolutely, thank you.
Okay. And Councilman Hiller, as we discussed kind of before we came on, and I'm not exactly sure when we came on the air, but there was a couple questions that you posed at the end. Liz and I kind of watched the video again to make sure that we got them. So I'll kind of encapsulate it, and if it's not accurate, then let me know.
Okay.
But there was a question, the first question that we had noted at the end of last session was an inquiry that you made about using vacation time substitution for suspension days. And so I wanted to talk specifically about that because, to be honest with you, I had to look that one up. That's not something that's been in my personal experience that I've ever seen, but there is a contractual FOP contract provision, Article 16, Section E, which is the disciplinary action section, that says it allows for a caveat for an employee to make a written request option to the chief of police on substitution of accrued vacation leave and or comp time for all or any portion of the suspension. It goes on to say that that's just the option to make a written request for the chief to consider. It is the chief's sole discretion, and that's the actual words that's in quote, sole discretion, to either grant or deny this request. There is no available grievance process for that particular chief's decision in the matter, so the chief's decision on whether to grant that request is final, and I have never gotten a request like that in my time as the interim chief, and I haven't seen one as a deputy chief either. So that's what I would tell you about that process. There is a contract subsection that would allow for at least them to make the written request for consideration of that by the chief, but it would be the chief's decision to grant it or not grant it.
Okay, that's interesting because you know that I've got concerns about a lot of us do, I think, on the issue of suspensions at all. And I was thinking that you had told me about that you were familiar, maybe not under your command, but that it had happened. Because in trying to just wrap my head around why we would even do this, besides that we've always done it that way, it was, I had to conclude that the suspension, which is rare in other venues, I mean, people need people to work. If they're not working, why would you give them time off?
Right.
For whatever reason, not, maybe a day or two, but never this volume of days that we've been talking about with PD routines. And I had finally concluded that had survived all these labor negotiations, because whereas personnel relationships are private, somebody's off work when they aren't on vacation. It's pretty obvious something's going on. So it would be, in a way, not only would sort of out the fact that this individual had transgressed in some way, but it also would demonstrate whether management was doing what management was supposed to do, which otherwise you'd never know if it was handled privately behind a closed door. And I mean, when you and I were talking about one time, I was like, aha, I think I have this figured out. And so for somebody to be able to use vacation or comp time and therefore not have the suspension, basically, seems a little contrary to that.
Well, hopefully this puts your mind at ease. I didn't and don't recall that conversation, but I actually called and talked to Director Russell about this section because I was kind of perplexed about it. Mm-hmm. And she couldn't recall a time either that it's not any kind of commonality. And at the end of the day, it's the chief's discretion as to whether or not it can occur. It's just the only provision in the contract that's guaranteed is they can submit a written request. So it was my intent to try to put you at ease a little bit.
Must have been somebody else who told me about the examples, because I think it has happened.
It certainly could have happened under a prior chief. It's in the contract where a written request can be considered. I can't speak with certainty other than my own experience.
Appreciate it. Thank you.
Okay. The second question that I had that we found was, you asked a question as it pertained to the steps of review within the chain of command. Were they necessary for corrective actions to the degree that we explained that they were? And how did that, and I think the follow-up internal question on that was, how did that work from an efficiency standpoint, or was that a very efficient process? And so I guess my short answer is back to that is I do think it's necessary. I think it's good because it assures a high quality of multi-layered assessment of the corrective action, and corrective action should be looked at by different levels to get a more holistic approach, perspective on what we're doing. It's also a good commander development piece for me and my staff of the future. In other words, for a lieutenant, a junior lieutenant, to see several of those as they come up through the process, I think prepares them for several years down the road as a captain or a major to broaden their experience level with these. As far as, and I knew the efficiency piece was a big one for you. We haven't run into a lot of problems with efficiency pieces on this because the contract mandates 7-day response from management, employee as they move through the grievance corrective action processes. So we're on a time clock, they're on a time clock as we go back and forth on these responses. So we move through it pretty efficiently and pretty quickly because we have to. A failure for either side to make that time frame and not get an extension of that time frame granted by the other party basically nullifies that process. So that would be my short version. It's my take on it. I think there's good value to it, not only because it gives us better decision making on the corrective action, it allows for a multitude of people to let their experiences view them from the lens, but it also helps me develop commanders from the future, and I haven't seen any issues with efficiency because we have a time frame that we're on from the very beginning that we're very well known to.
Could I ask Jim a question? So about how much time does it take to review a typical case? My experience is just reading an IPA report, right?
A typical case, that's the only reason why I kind of chuckled
Well,
a little bit.
average it out or give us a range.
You know, it's got to be within those time frames is what I would tell you. So some are quicker than others, but those corrective action forms that are reviewed, I mean, for the most part, that's a one-page document. Now, the underlying reports and narratives and stuff like that can be a lot more, but that corrective action form document is not a very extensive document itself that basically summarizes everything. So, and the IPA report, you know, we're talking about, these are corrective actions, not uses of force. Now, the IPA does look at both, so you may be thinking of that. I just want to make sure.
I was only thinking, and the IPA report is a very condensed
right.
report of what that case was, and I've never seen all the detail of a full, I've done case files, of course. I know what an extensive case file looks like in general, but not yours. And so, because what I'm remembering is that, you know, my thought was if it takes 30 minutes to read each file,
right,
there's a big difference management-wise. You know what happens with the police department if people say they're top-heavy, right? We've heard that before, let's just say. So if it's going through 5 steps at a half hour a person, and they all see the same thing, and then it gets to you, that's 2.5 hours to get that case file to you, versus if 2 people look at it, it's an hour.
right.
You know, when you add all that up with reading files and just going through those bureaucratic steps, there's old jokes about how many people it takes to screw a light bulb, for instance. You know, and so just from a management and personnel use of time, especially when we talk about being short of officers on the street, that's partly where that question was coming from. Also, I think I recall correctly, and maybe anybody here can help me out, when the independent police auditor first came on board, if I'm correct, one of his first, when he was doing his first set of reviews, there was a case that had gone all the way through all those checkoffs that when he reviewed the case, said, you know what, this needed a different evaluation. And in fact, there was a review of it, and it got kicked back, and some action was taken, if I'm not mistaken.
Yeah, that would make my point that more eyes looking at it is better, and it's a worthwhile endeavor. That's certainly my perspective.
But if it went through 5 people and everybody said, fine, 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 fine,
right,
and it took an outsider to look at it and go, why did everyone all the way up this chain of command spend all that kind of time when somebody should have spoken up?
Yeah, I think it's important to know about specific examples, but we're talking about a process in general that's used for a lot of them. So we can point to a specific example, and that's not necessarily a undermining of the entire process. This process works for a multitude of cases, and so The one is one, I guess,
Well,
is what
and-
I'd say.
One of the things I remember with that particular, if it's the same one I'm thinking of, the issue that was evaluated on that particular individual wasn't the item that the IPA diagnosed. The IPA diagnosed another underlying issue or concern
Okay.
that was related to the primary investigation that was being conducted. He determined that there was some additional training or action that he felt was something that the department should consider as a whole, because he saw it in that one and then saw it in another one and felt like it should be brought up to the chief, is because he felt there was a training moment that needed to be solidified within the organization.
Okay.
But that's a part of his job too, am I correct?
Yes, it is.
Is
It
to
is.
not only look at that incident, but to also look at where we failed in these incidents,
Yes.
where we're falling short. And that's something that's always stuck out to me is it's good to have him look at it like however many he looked at to say, here we go again.
Right.
Here we go again.
Yep.
Here we go again. Okay, this needs to be mentioned at some point, because he's seeing it firsthand.
Right. Very much so.
And, excuse me, and the other, the chief is not seeing that, and that might be because he's not looking at all of them the way that the,
Right.
independent
He-
auditor is.
He sees 20 to 30 cases each month, less or more depending on the time of year.
Right.
And so, yes, he can see trends, and that's not something that even one shift commander can see, because it can be all across multiple shifts.
Right, right. So that's why I appreciated that, just again, looking through the lens. Here's another guy, with a different angle.
Yeah, and it wasn't a life or death type issue, but it was
Right.
one that could lead to additional confrontations or issues based on the procedures they were following.
I do remember that now, because I'm sitting there like, what are we talking about?
Yeah.
Okay.
Well,
yeah.
I'm glad I'm not, at least I'm batting 500, right?
I'm glad the city manager was here to know the details on that one.
And I bring these things up because we're here, because citizens were concerned that things were just sliding. That's why we're here. I got a feedback kind of along these lines of someone who's been in reviewing the independent police auditor reports, and every one of them so far, and I didn't bring mine, has had at the top that there were, I don't know what the phrase is, I think it's the same on each, basically that no breach of policy was uncovered.
Correct.
Yet you get to the end of that report, and then there's the list of all the disciplinary actions that occurred. And so it's like, well, and this was someone who'd been reading them, it's like, well, then things didn't go quite right. Why does the top of the report say everything's fine when we had this array of disciplinary actions?
And it's primarily because there are two levels of occurrence that happen when it comes to the PSU investigations. They look for breaches of how you call it, procedure, those types of things. They look for mistakes that are made by the officer in the incident. IPA is looking at both the violation of that individual's personal rights and the use of force, and whether or not excessive use of force was utilized, but also the PSU is looking at that, and did they breach the department policies that were established? Did he not stand in the proper spot when he conducted the traffic stop? Does there need to be remedial training as it relates to that individual because of the way he conducted whatever action was recorded? That then can result in a discussion with that officer. Didn't affect the use of force, that was proper, but it could affect the actions that he took because he didn't follow policy.
We might want to think about those headings again.
Sure.
Yeah, no, I can see the point that you're making. In other words, if you have a use of force incident and the use of force incident was found to be justified, but the officer didn't, turn his camera on, or he didn't go out on the radio as the
De-escalate
call,
appropriately,
right?
he did whatever.
He did the procedure. There's a procedural violation. So, like you
Yeah.
said, there's probably a header. If you say breach of policy, I can understand where the concern would be, because it doesn't make the difference between a major policy and a minor policy. So it makes sense.
Right, and it makes it look like, we're taking another layer of just looking at everything and saying it's fine.
But that's another point, though, because that's the point you're making. I would make the point that a different set of eyes looking at that document sees that perspective different, that it says no breach of policy at the top and then lists corrective actions down at the bottom. I think that's why those discussions and different sets of eyes are important to look at.
I agree. I mean, we're just trying to make sure that
Sure.
we're really catching things, that we're not going through motions and just going through motions because
Yeah.
it's our job.
I agree.
That's why we're here. So,
Sure.
thank you. Thank you.
Okay, continue on.
There was just the two questions, right?
Right. It was. I'm sorry. I was taking a little water break here.
You're done.
Right. Yeah. As far as those two questions, Madam Chairman, if you're ready for me to move on with the next presentation about juveniles, we can do that.
Yes, yes. First, can you define juveniles for me?
I can, and actually, it's on the second.
Okay. Awesome.
The second slide. Or at least the category of a juvenile offender. But I think it kind of goes to the heart of what we talk about. What are the age parameters and
Right.
the timeframes is, I think, the question that you were probably headed to. But as we start this discussion on juvenile procedures and the differences, the policy is about, it's 19 pages, that handles a bunch of different areas that are different. It kind of differentiates between how we handle juveniles in situations similar to how we would handle adults and where those legal distinctions are at. And those are kind of the high points that I tried to hit as we move through this. But the legal foundation, the policy number for the juveniles is the 4.14. It is available under that number. It is based on the Kansas Juvenile Justice Code. Those are the appropriate Kansas statutes that are annotated up there, 38-2301 and 2330. But it specifically does define a juvenile offender, which I thought was pretty astute since the chairwoman just asked it. But I think you have to define some of those categories so that you know what in term you're talking about. And there's some important distinctions in this definition. The state of Kansas, and it says a person who commits an offense while 10 or more years of age, but less than 18 years of age. So in between 10 years old and not 18 is what we consider to be a juvenile. In the state of Kansas, anybody who's under the age of 10 years old cannot be held criminally responsible for any of their actions. And there's a lot of case law and long-term historical data as why that is. But that's what the definition of is when we talk about juveniles. And the kind of cases that we're dealing with in this discussion and section. But anything that they would commit, an offense that would be considered to be a felony or a misdemeanor if they were in fact an adult and they were not between the ages of 10 and not quite 18 would be what we're talking about today. State law mandates that law enforcement must investigate cases of serious injury, death, sexual abuse of children, defined as juveniles here. A juvenile who is taken into custody shall be brought without unnecessary delay. And a lot of this is specific language out of the policy because the language in the policy is derived a lot from statutes, and so it kind of matters. But without unnecessary delay to the parent, guardian, or custodian, with a couple of exceptions, unless there are reasonable grounds to believe that such an action would not be in the best interest of the child. And I think we can all understand if we are investigating a child abuse case, then obviously we wouldn't turn them over to the parent who might be part of the issue that we're investigating, at least until we've moved through that process, or would pose a risk to public safety. That's the general law enforcement exception to any action if we're not going to do anything that we can articulate would pose a risk to public safety. Next slide. One of the other specific things that we are, and I'll talk as we're doing, one of the other specific categories that's very specialized to our law enforcement contact with juvenile subjects is this requirement to do an assessment regardless of what the initial situation is that law enforcement is called out to. We're required in all situations to complete some basic environmental needs assessments, and I gave some examples up there as to the welfare of the juveniles, lack of food, water, unsanitary living conditions. So there are a number of types of calls for police service that start out one way. Could be anything from a disturbance to, even a fire scene or a traffic accident, that if we see obvious and articulable documented facts that lead us to have concerns for the welfare of the juvenile, we can move into a police protective custody situation and move through the juvenile intake process with DCF and our partners.
But if I may, but that's only if a child is in that home, is present,
Right.
correct? If
Right.
the child, that's what I'd like to see change. If the child is not present, but you see all these child things and you go in and do a drug bust, there's nothing you can do because the child has to be present. Even though we know what's going on, whether it's a meth or whatever, that's my own little.
No, it's mine too. We do in situations, and I think it's important to point that out. You're exactly right, where the kids are
and
present.
the reason why I say that it's my own personal battle, it is. But at the end of the day, you get so many constituents that say they know they're on drugs and they got kids and they still have the kids. So they didn't do, the police didn't do their job by removing them. Even though you can turn that into DCF, that doesn't mean anything because we can't take them out of the home at that particular time unless they're present. And if they're not there, we can't do anything. And that's just something I'd like to see us. It's not us, but something how we can turn that around to do a better job at identifying that and getting them kids out of there.
I think it's a great discussion point, and it does flow into the next part that I want to talk about too.
If I
though.
can piggyback
Oh,
on
sure,
that,
go.
because I was in a session this morning which included Rebecca Morrissey, the principal at Topeka High, and she was talking about that same sort of thing. The whole group was talking about middle school and high school kids in that case, and she I'm not going to be able to cite chapter and verse like she could and like you guys could, but she said, ever since the change in the law happened for juvenile policy with the state, it has troubled her. And she said, I know why it's there, but was concerned it wasn't working. And just this morning I said, well, even though that's not something we're over exactly, if you all would bring it to us, to me it's appropriate for us as a city to have it on our legislative agenda and explore that with, for you all to bring to us things that, no, maybe we're not responsible for it overall, but if the state law regarding juveniles, let's say, should be changed and we can make a suggestion as to why and how, because it's just the right thing, let's say, I think we should have those kinds of things on our agenda as well and try and help out.
I agree.
Yeah, well, that's another discussion, another topic, but I did want to say that while we're in this meeting because because of the line of work that I do and because of, I hear from my constituents that, that was a meth house and the kids are still there, and the police didn't do their job. And I do understand that because, grandma will come and get the kids or they'll shift them to a neighbor or something before we have time to do anything. And it's really hurtful because at the end of the day, we get to them, but the suffering that they have to endure until we can get to them is just, to me, is just crazy.
Right, and that was her point, was that, to know that you're sending those kids home, that it's not a safe place to be.
But the one thing that I do like that we've done, that I'm seeing more and more, I'm seeing more and more in the schools is the middle schools now have social workers. They have more social workers. So what they do is they run a tab on these children that they can look at, and they can also see all of those that are in DCF custody to check on them, whether something's going on or whether they've gone back in the home or whether there's something at the start of the home. So they're dedicated to that because we lost a lot of our workers to that. But I thought it's a great program that they're more in touch with them to get to those kids. COVID has really put us in an awkward position because we really rely on those social workers, law enforcement and the social workers at DCF. They rely on the schools to kind of to be a set of our eyes and ears. And with COVID and so many at home, we're just not seeing it.
Well,
but there's so much neglect out there.
Right.
It's really, really sad.
Because what she it was in the context of saying, school for some of these kids is the only safe place they
Yep.
have, and it's safe
Yep.
for 8 hours a day, and they get 3 meals. And when school's not in session, the kids don't have that,
Yep,
and it's hard.
yep. So, I just wanted you guys to feel my pain for a minute, that's all, I
Yeah,
guess.
thank you.
Yeah, the only thing I would piggyback on that is for those situations where the kids are in the home, we do aggravated endangering of a child when there's articulable facts, and that is a person felony that we can add. And so you're exactly right, and you know
But
the
they
nuances.
have to be there. They
you're-
have to be
right.
present
Yep.
when we arrive.
Right, and we can still, like you said, document the conditions, but you're right. It is very much a caveat that they have to be present,
But
because
when
that's
you-
part of the offense.
But if you're taking them home, then assessing the environment on arrival
Right.
can occur.
Right. Oh, yeah, and, or I mean, this was a very specific set of circumstances
Okay.
with the drug raid. But if we're out on the call at the house it could be you could have something stolen from your house and come out there, and we still are going to assess if there are juveniles in the house while we're there taking the report from you, where you were. Any kind of call for service you can think of that puts us in contact with a juvenile, those kind of assessments are being made.
Well, we were talking about incidents, for instance, where the kids are going into some vacant house and just hanging out or messing around and causing damage, or being in a park and getting in kind of a rumble,
Yeah.
those kinds of things.
Yeah, all of those. And, okay, so moving forward, the status offenses, and this is another distinction that we make that's very specific to juveniles. Officers have discretion, and they should use discretion, as the policy says, when they're dealing with the status offense. And so for me to say that, I need to tell you what a status offense is. It's a non-criminal misdemeanor that would not be a crime if committed by an adult. And I gave you an example. So a minor in possession of alcohol, or an underage person in possession of tobacco, those are not offenses for an adult. They're only offenses because this person is not of the age that is required. And so that's a status offense that we have. And juveniles are specific to that. Runaways can be a status offense. Runaways can also be a child in need of care, depending upon what the specifics of the situation are. But it's important for the committee and for the community to understand that there are some offenses that part of the criteria is the age. That wouldn't be an offense if we were dealing with an adult. Next slide, please. We talked about this, and it's in there a couple different times. Officers have a duty to make reasonable efforts to notify the parent, guardian, or custodian of any youth. That's somebody who's under the age of 18, under the following sets of circumstances. And I think these are kind of the general questions that I get a lot of times in the community. But these are the circumstances in which that notification of the parent, guardian, or custodian is required. Where they're taken into custody, there's not an age piece to that one. Subject to any enforcement action, which could be what we talked about if you were caught in the park fighting, as you talked about, or we're in park with a alcohol or tobacco, something of that nature. Detained for a significant period of time, or interviewed as a criminal suspect. And this is a question that we get lots of different times as to what are the age ranges where the parents have to be present for interviews, what are they where they're not. So a child under the age of 14 must have, and when we use language like must have in our policies, it comes out of statutes, and must is a requirement. It's not a shall, it's a must. So have parent or guardian present before being interviewed or read their Miranda warning. So we don't do in cases where a juvenile offender is being detained and being interviewed, they cannot waive their Miranda rights without a parent or guardian present. And then officers have a responsibility to not only document the notification, the efforts that were made, and the responses that they gain from those as well.
So you're saying from 14 to 17, we can question them without a parent?
And there's another slide later on, but
Okay.
I'll go ahead and jump to it. But essentially, yes, you can by state law, depending upon you establishing the understanding of Miranda based on the capabilities and capacity of that child. Those interviews at the police department are done in recorded audio and video recording.
What if they refuse?
What's that?
Do they have a right to refuse?
Do they have a right to review?
Refuse.
Oh, refuse. I'm sorry, I couldn't hear what the message. Yes, absolutely. Same as anybody
Miranda
else.
right.
What's that?
Similar, same Miranda right.
Yeah, same Miranda warning. And in the experience, I mean, you have to demonstrate. When I say and this is probably part I have to do. So when I say you have to demonstrate the capability and the understanding of Miranda, there's a process that we do with adults too before we read the Miranda warning. In other words, the basic questions that we ask for an arrest report: your name, your address, your date of birth, your phone number, your social security number, those kind of things. While they're needed for the paperwork that we're going to fill out in the investigation, they also kind of establish your competency level and your capacity to understand things. I always used to ask, do you know where you're at? Police station, do you know who you're talking to? A police detective, do you know what the date is? A lot of those things. And then as you go through the Miranda warning, the Miranda warning has very specific language that you have to use that's on the card that's issued. And you go through, do you understand these rights as read to you, and all of those things too. So it's kind of a total combination of all of those things. And the detective or the officer in the interview room makes their own assessment and judgment on it. But at the end of the day, it's ultimately reviewed by the district attorney's office on the charges, and ultimately a judge if there's any question as to the competency of whether that statement should come in or not, because there's all kinds of motions to suppress and stuff as you move through the cases. So there's a multi-layered review process. But the clear part is under the age of 14, you have to have the parent, guardian, or custodian in the room. 14 to 18, you have to establish all those things that I said. They absolutely have the same right to invoke their Miranda right, not answer any questions as anybody else does. In these situations, the parent or guardian can refuse and invoke that same right to remain silent as well. Go ahead, the next one.
I think if you'll go back for just a second,
Okay.
I think you were notified, maybe not, I don't know, but there was 2 young African-American kids that were at the YMCA, and their father, actually an officer started questioning them because something got stolen, and they didn't want to answer. They asked if they could call their father, and they were like, no, you have to answer us.
If it's the incident that I'm referring to, I believe the actual law enforcement officer, TPD was there to assist, but it was a KHP officer who began the questioning.
That's right.
As
You're
far
right.
as the complaint.
You're right, it was, yeah.
So
that's why I'm asking, if any kid between 14 and 17 say, hey, I don't want to answer your questions without my parent being present, do they have that right?
first of all, they have the right to refuse, but if they're under 14, you have to have their parent there.
I got that.
Before you can even ask them.
Right, I got that.
But yes, 14 to 17 and almost 18, they can refuse to answer questions just like anybody else. There is, the Miranda's available. It's just, the difference here is that under a certain age, your parent makes the decision
14 and under.
as opposed to you making it for yourself.
How they were telling him that, then they should have just asked for their parent, right?
Right.
And not been questioned or not told that they had to and blah, blah, blah. Because that's the thing, you're scaring kids, because these are good boys. I know them. I know their dad. They're good kids, and they were scared. And then they were told they had no right, but they had to. That just even makes it worse.
Right.
Okay.
I only recall that incident because it was specifics. It did come through me to investigate, and we were identified it wasn't our personnel that was.
You're right. Now that you said that, you're right.
So.
Okay.
And that's the thing on a bigger discussion. I mean, we have to demonstrate capacity and capability to understand Miranda for anyone. I mean, when we're dealing with special need populations and anything like that, and those things are decisions that are made in the interview room, but they are reviewed by the district attorney and the judges too, ultimately, as to whether they're used as evidence or not. So it's a multi-layered process as far as Miranda goes. Enforcement alternatives. A lot of things that we have discretion with juveniles with the best interest of them being the main guiding force of this. We can release without further actions, and officers use a lot of reasonable alternatives when dealing with juveniles because of some of these nuances that we've talked about. We have informal counseling to the youth about future consequences of actions. We get called out to assist citizens who are dealing with their children on a lot of things. Sometimes that you're not going to bed on time, and some things that aren't anything that are necessarily police things, but they use us. They work with us to have frank discussions with their kids to try to enforce some of those things and try to deter things that concern them in the future. Informal referral to available community service agencies. We have a lot of great partnerships in town in which we do a lot of great community youth outreach services and identify, and that's what this refers to. And then, of course, informal counseling of parents and guardians. We try to do those same services for the parents and guardians, and we actually do have a lot of people that ask us about, what would you suggest type situations. Next slide. This is just some more of the options that we have. We have limited custody and official warning. So in other words, like we get it, and I tried to give some examples of this because I know sometimes that's more helpful than the language that we use, the jargon that we use. But so an example, you have a runaway who's reported, you locate that runaway, you take them into custody long enough until you get their parents contacted and you can turn them back over to their parents. That's what limited custody means, and we'll go into a non-custody setting and all these other things here in just a little bit. We also have the ability on some of these status offenses like we talked about before for possession of tobacco to issue a citation or a summons to appear to court later. Those are issued to the juvenile, but also a place where the parent signs or is made aware of the court dates. And those go through not only the juvenile intake process, but also the district attorney's office. Is kind of a double-layered approach to deal with situations if they don't show up for court and those kind of things. And those tickets are just like regular tickets. They can go out on warrant and can be the foundation for taking someone into custody and then having them processed through the juvenile detention center to go to court if it gets to a certain level. Not generally the trajectory of those cases, however. And then, of course, the standard more for juvenile offenders, the referral of court cases, just like we can do with adults on criminal complaints through the district attorney's office. And then I've got arrest under non-secure custody, and I want to talk a little bit about that, and then arrest under secure custody. So if you're under arrest for an offense, let's use your example of fighting in the park. The officers get there, they secure the scene, they stop the disturbance in process, they secure the juveniles and sort out who's who and start calling parents to come get them. They might be seated in the back of police cars and secured and separated, or they could be standing at the front of the car and different places depending on how many we have. Those would technically still be in custody, but not secure custody. Secure custody has a very specific meaning, and if you click the next slide, that's what it says there. But it's essentially a detention condition where the juvenile is confined in a locked room or cell that is designed for that specific purpose, who are in securely detaining law enforcement in custody. And as you say, the second thing there says, so if they're in a vehicle being transported or held before they're released to their parent, that's not considered to be secure custody. Secure custody is very specific in regards to, essentially for us here in Topeka, it's JDC, Juvenile Detention Center. A couple other little nuances about things that are different for juvenile processing with law enforcement. All fingerprints and photographs of juvenile 14 and under who are taken into custody for criminal offenses shall be maintained at the Juvenile Department of Corrections. So we don't have any of that at the Topeka Police Department or at the Sheriff's Office for that matter. All juvenile records, that means that pertain to those criminal investigations, are maintained at the police department in the records section, but they're kept separate. And they have much stricter laws in regards to the dissemination of information provided to juvenile cases. And I think the community is fairly educated on that from a media release standpoint. There are certain juvenile information we are allowed to protect by law as far as identification stuff to a higher degree than we are adult information. And this is just a reiteration of that same point, the question I get asked all the time, but 14 years of age, you got to have the ability to consult with a parent, guardian, or attorney to waive the right. And then this is the other side I was talking about. You basically have to, what I already explained, you basically have to establish the level of competency and capacity between 14 and over of a juvenile subject and make reasonable assurances. And that goes for a judicial review at the end of the day. The officer has the right to take a child into custody when he or she believes the child is in danger. There's some latitude there for the child welfare being the predominant factor. But the officers have to be able to articulate the grounds that they are basing that seizure of the child on, based on their observations, interviews, and evidence collected. And this is one of those pieces of information that we like to get out there too. Parents do not have the right to refuse officers access to any child if they're involved in a allegation of child abuse settings. In fact, we have requirements now under Adrian's law that's a relatively new situation that requires law enforcement to have visual contact with the child in those type of situations. If the officer has probable cause, and that's based on, as we talked about before, the articulatable observations, interviews, and evidence collected to believe the child is in an imminent danger, the officer may enter the home to check on the child's welfare. Okay, just touching on some other additional points that are very specific to law enforcement dealings with children. CIB, which is shorthand, Detectives, Criminal Investigative Bureau personnel, or Division of Child and Family Services may interview school-age victims in school where appropriate. As you pointed out, in some of the kids' lives that were in, school is the most stable and safe environment that they have, and so that would be the most appropriate place for interviews that need to take place related to investigations. Child in need of care is a person that's less than 18 years of age at the time of the filing of the petition and needs to be, or the protective custody order, and it basically goes then through the whole a variety of situations and circumstances that are all examples of the kind of information that officers need to be able to articulate and to have collected to establish a child in need of care situation to advocate for police protective custody or placement outside of the current environment that they're in. It asks the questions about parental care, control, the condition of the situation that they're in, the physical, mental, or emotional health that's been observed of the child, whether or not there's any signs of physical, mental, or emotional abuse or neglect, and has been placed for care adoption in violation of the law. And that pertains to CHIP specifically when there are court orders in place for different things that have been determined by a court. Obviously, the police department, law enforcement is mandated to enforce those orders. Has been abandoned or does not have a living parent. We do have situations where we respond to unattended death situations where we have juveniles in the home and we have to move through a process with juvenile intake and assessment to find next of kin or guardians or some kind of temporary placement while those situations can be resolved. And of course we have is not attending school as required, which is why the communication between law enforcement, DCF, and the schools, as has already been talked about, is so important. I want to touch a little bit on this. This is one of the founding tenets in this policy is that the Topeka Police Department is committed to developing and implementing programs designed to prevent and control juvenile delinquency. And then I listed, and the policy does in fact list a number of these programs, which I know we have talked about in other venues, but I still thought it was worth putting up there. I mean, we're actively involved in the schools, school resource officers, TCALC officer. We have a youth outreach program of our Explorer Post where they come in and they learn about law enforcement activities and processes at the police department. The OK program is a African American male mentorship program that we were one of the first agencies to get on board with, and Tim Bell does a great job with that. A more recent addition has been that has received media attention and is a great program is the Three Shields Boxing Academy through the Salvation Army and the Police Athletic League. And of course we have the Boys and Girls Club leadership program, summers over the last few summers, and the development of chess teams. Police Athletic League is very involved with the Boys and Girls Club on a number of sports as well. And with that, as the final slide for this presentation, I will stand for questions.
Do you have any questions, Karen? No. Okay, I don't have any questions either.
Okay.
Okay, let's go to other items. Chiefs Advisory Board.
Okay, well, I appreciate the opportunity to talk a little bit about this, about my vision specifically as it pertains to this.
Yes, let's make it clear, it's a vision right at this point.
That's correct. That's absolutely correct. And I think a little background of that, the Chiefs Advisory Board or Council has had several different names over several different chiefs and their tenures. We did not have a Chiefs Advisory Board or a similar entity in 2021 as I moved through the interim process as a month-to-month employee. And I've said in other venues, and I'd like the opportunity to say here, the reason why I did that was I felt somewhat disingenuous to ask members of our community leaders to give me the amount of time and dedication it was going to take to sit on the board when we didn't really know exactly how long I was going to be in the position. But it is a priority of mine in 2022, now that we have resolved the chief of police position to some degree, and to move forward and develop that process. And I've already been in the process of identifying, and I'm going to spend a period of time in the first part of 2022 meeting with a lot of different community groups and seeking counsel from a lot of different people to try and have a diverse Chiefs Advisory Board to give me input on a variety of issues, to meet with me on a periodic time and talk about those. And I can tell you a couple of the nuances that I've learned in the variations that I've seen other chiefs do with this has led me to a couple of decisions that I want to do with it. It's the most effective groups I've seen have somewhere been in the size of 10, 12, 15 people. That's about as many people as you can get on a board, in my experience, and still move things productively through. But beyond that, I have the vision that I want to break the bigger group, meet quarterly with the bigger group, but monthly I want to meet with 3 and 4 person working groups to have more one-on-one input with me and give them more of a time and an opportunity to talk directly to me about those issues once they're identified. Sometimes in my board experience, you have dominant personalities who then give a lot of information in the meetings, and so therefore it doesn't necessarily give everybody the opportunity to do that. So the meeting schedule is kind of an experience thing that I've seen from other chiefs, but the primary reason why I wanted to talk about this, and especially in this committee, was to, one, answer the question about, why we didn't have one in 2021, and 2, to assure the community members and the committee members that this is a top priority of mine and I'm moving through it. But I am going to do it somewhat methodically, because I think the other lesson I've learned from the experience is once you form this board, it is formed. And so the decision about who is on this board and making it as wide span and as diverse as it can be is one of the things that I'm going to spend a great deal of time talking to a lot of people about and seeking their guidance. And I've already started that process, and I've already gotten some great feedback beyond what I would think of as normal diversity. I was talking with a community member that I have come to respect quite a bit, and they made the point to me that don't forget, Chief, when you're looking at diversity, that you look at economic status diversity as well, not just diversity of what we normally think of: gender, ethnicity, religious, those kind of things. And so I think those kind of conversations where I take little pieces of experience from people who have a lot more experience than I do will serve me well. But I will move forward. I'm going to meet with a lot of groups. I appreciate the opportunity to say this to the committee, because I'm saying to the public, if this is something that you think that you would be interested in, feel free to reach out to the chief's office. I would like to meet with as wide a group as I can and get as many different perspectives on what the priorities of that group should be and what the makeup of that group should be before we make that process. But ultimately, it will be a group of community leaders that I meet with very regularly, and that who, even when I'm not meeting with them, I have contact with them, phone, email, on a number of issues as things come up, to ensure that my perspective is broadened by a lot of people's experiences beyond just my own, and definitely just beyond those people that are within the department too.
Well, that sounds good to me. I just, one thing that I would say is, I hope we find some new people. I hope we pull some people out of the wood and find some new people,
Yes, ma'am.
because everybody can bring something to the table.
I heard the community loud and clear in recent times about the city Rolodex and those things, and I agree. I'm willing to put in the legwork and meet people where they are and listen to what they have and consider a lot of options. I'm just asking for people to have those conversations with me.
I think that's also a good number. Sometimes you can get too many, and you're right, it just doesn't settle.
Yeah, I'm not looking to just have a meeting. I'm looking to have value come out of those conversations.
If I could ask, then, we have various committees, of course.
Sure.
Two questions. One, what level of engagement and what kind of agendas are you expecting with the big group and the smaller groups? And either related or not, are you thinking right now of developing any other groups regarding policing, racial bias, and so on at this point?
I guess I'll take the second question first. No, my focus, I hadn't thought about any other groups. My primary focus right now was on this advisory council. And the big meeting, I would look at broad topics of general things. The small meetings, depending on how the makeup of the group shakes out, I would look at those to be more focused on specific areas of expertise. And I think that those big meetings, I think the first meeting initially is going to be the whole big group, and I think we're going to collectively talk about some of those things and decide, and let a little bit of that form up naturally into the smaller groups. But I'm a big believer and have seen success in my past with having a larger working group that addresses big issues and then breaking down into smaller groups when you have areas of expertise. So that's kind of my vision. I hadn't thought about any other formation of groups beyond that. That's going to keep me busy for a little while.
And I think that's great. I might be getting ahead of where the chair wants us to be, but in the tenure before you became interim, we'd had an LEPP for a while, and it just sort of faded, and then we had the SPCP for a couple of years, and it's now over. We had a gentleman, Kane Davis, who was doing the Strategic Leadership Academy for a while. He's now out of town. Apparently, they're about to miss a meeting, and so there've been movements that either were established by the department or in the community in the past, and so you can have too many, just like too many layers. So if you're feeling, just kind of feeling out at this point as you're visioning your chief's advisory committee, whether you were envisioning seeing anything else develop or redevelop as well.
I'm not familiar with LEEPA. I am obviously familiar with the SPCP, and I am very familiar with Mr. Davis's Strategic Leadership Academy and having presented to it a number of times. But I would say that's my focus is on the Chiefs Advisory Board. The focus of the advisory board will be on law enforcement related topics and community relations. I certainly think I would be interested in, and I think that the police department would bring value to any city level committees of that nature too. So I don't know if there's any of those in the work, but
you're looking at a not only broad but deep, I suppose, diversity in that 10 to 15 that you're recruiting.
Absolutely, and
Or-
with all of the experience and caveats that I've gained here today, not just, and being out in the street and having lots of formative conversations before I make the pick, the picks that they are, and I think we need to make sure that we have young and old as well. That was one of the things that brought to me, so I'm very interested in seeing where those conversations will go. I don't claim to be the smartest or the end-all be-all, but I am a worker, and I always have been a worker, and I'm going to put in the work to make sure that I get the kind of group together that I'm talking about. And like I said, I hope to see and meet a lot of people that I don't know right now as we're talking. I didn't just go, okay, here's the people, that I think of right now. I know enough to know that there's a lot of people that I need to meet before I make those decisions.
Thank you. Thank you.
Okay, City Manager, you have been with us on this long, tedious ride. I heard you the other night say you're anxious to see what's going to come out of this committee. I'm anxious to see that too.
Yeah.
But I just wanted to personally thank you because you've been riding with us. And do you have anything to add? I know this will probably be your last meeting, unless you want to zoom in. I don't know what your plans are.
I don't know what my schedule's going to be, but yeah. I guess the thing that I'd leave you with is that
And you can leave us with recommendations. You can leave us with
Sure, I think-
whatever.
I think probably what I would be best is that I write those out and give those to you as far as some of those items. I don't have any of that information, and it would be just off the cuff, and I'd probably miss something. So, but what I would say is that there aren't a lot of elected bodies that agree to spend the time, and even though it's been primarily 3 of you that have spent the time each month doing it, we've had the other council members that have supported that you continue to spend the time and effort, and that they're anxious to allow and have their chance to become engaged once you figure out where this needs to go and what recommendations you'll have that the city as a whole needs to be considering for actions across, obviously primarily the police department, but there may be other departments that are affected as well by the things that are brought forward. But I think the bottom line is that it's been an opportunity to dig deeper to understand the guidelines and things that we do and understand how the police force works and the different policies that we implement more than I can ever imagine any organization I've been involved with to do so. And to take that time is obviously your personal time, because this is an additional committee, not one of the standing ones. It's an additional committee, and you're spending extra time to do. That's a commitment that shows something. Some may be critical of the fact that we haven't made a decision yet on anything or made any recommendations. There's a lot here that needed to be looked at before you could ever feel comfortable going back to some of the things that were recommended by citizens, and some of the things that actually there were some governing body members that were willing to sign on to as being policies of the city. It's the effort to be able to determine what's right for our city and what needs to change for our city, not what is going on a national level. And the only way you find out where that is by spending the extra time with, besides the chief, the other members of the management team of the police department and their presentations they've done, and other organizations. I mean, having C-Post here, who would have thought we'd get the state organization here to talk about how they control ensuring that good cops are what we keep, and that there are things that are done to ensure that bad cops don't continue in that role. And so I look forward to, and I'll write some things down and give them to you for just your thoughts as you go forward.
Well, I look forward to getting those. I just want to say, back in my Father's Day, he got drafted into the service. I got drafted. I don't know about Karen, but I got drafted. So what do? You just serve out your time, right?
That's right. And you try to do it with glee.
I'm trying. So anyway, well, thank you. Good luck to you, and hopefully you have learned something out of this as well.
Oh, no, there is no doubt. I have learned a tremendous amount, and things to watch for as I continue in my career.
Okay, thank you.
Yeah.
Is there anything else to come before the council?
Not by me, thank you.
Okay, if not, we will adjourn this meeting.
Okay.
Thank you.